Good. Yeah. Mhm. Let's see, if I start talking, will you start doing it? Yes. Okay.
So that all works pretty well. How far out is it? Yeah,
Like at our meetings, we'll have two little mics we run out, but it'll be pretty good. And it kind of senses who's talking, and so kind of like
turns.
move around. But unfortunately, you can't see it moving, so you're like, is it moving? But let's see if I go over here and talk for a minute. Just say something.
Hello, Howard. Yeah, the colleagues are talking for one seminar classrooms. We don't have wired mics.
At the town office, it works pretty good.
Yeah, it's a nice small thing. Right, but there could be people for hearing. I think a little further from the table. Yeah, so that's.
Yeah.
So you can see at least all out there in small form.
Yeah.
For me, that'd be best if I stand back here. Right, if I stand like right here, it just sees my tummy, which is not a flattering, and especially because it's low, you know. I really should be like up here.
Oh, yeah.
Sometimes I'll see videos myself.
Oh, yeah. Good.
So how many people do you think will be here?
Well, supposedly the whole select board, which is 5, and then,
The DRB.
yeah. The zoning administrator. Are all supposed to be here.
Well, good. And we usually will get like a couple of nearby folks, and sometimes we get far folks, I've had folks from, like Hero. Jericho. I don't know. Sometimes you have to be like, hey, you can certainly be here and be like, watch all you want. You're not my town, just. Every now and then we have one. I think people call us up because they call their regional planning. They want it,
Yeah.
like asking mom when dad is giving them.
Oh, yeah. Yeah, I'm on the DRB, we spend a lot of time explaining, no, we don't make up the rules, we just, here are the rules, we just.
Yes. Which is a big part of it is everything is not up for grabs all the time. At least that's not the system.
It just takes time, it takes time to change the rules,
Yes.
and then. Yeah, we need to do things like changing our forms so that if you apply for a waiver, the form asks you to give your reasons.
Oh, okay.
It does, and so then, the hearing turns into, we have to have reasons. Well, nobody told me I had to have one. Communication.
Mm-hmm. just so you know, the recording is, the Zoom recording is live.
That's okay, I'm used to it.
Whatever you say can be used against you.
Where did that one?
Hi.
touch
Oh, hi. Hi.
I really was
Good.
good.
How's it going up on the hill there?
Quiet.
You still a sheep?
No. Sold them 17.
Oh, okay. And you had a big ornery llama, if I remember it. Like a kind of a,
Several of them actually.
oh, this one I remember was kind of like a brownish one.
Yeah. He was very effective.
I was like,
Yes, he was big boy, yeah.
yeah, surprisingly.
Yeah.
Not like
He
a
was,
skinny character.
his job was protect the sheep. And he did a very good job of it. He was very gentle with the sheep. And he was fine with bait. And that's all
That's all he's supposed to do.
he loved to walk out to people and kind of look down.
Yeah, yeah,
Yeah.
I can remember him thinking like, okay,
Yeah.
you're the boss.
Yep. Anyway, it's very quiet without talking.
Good character.
Tell me about it. I spent 62 years with him.
I always remember his giant vest.
Yeah, he had his own way of doing things.
Yes, yeah. Well, that's perfectly fine. I'd rather have people who are kind of.
I think part of it was a defensive mechanism that people then would keep their distance.
Oh, maybe it's like engineers.
Well, I could
It's
be.
Pete in our office is,
Mhm.
his dad's an engineer, so Pete kind of begins every conversation with no. And then you kind of work your way.
Yeah. They have certainly the ones that we dealt with has a very interesting way of dealing with things. And to other engineers, they would understand that, but to the outsiders.
Well, and it's you know, it's a to me, it's a field that isn't it isn't driven by whether you like it, they
Mhm.
want to stand up or want to stand up. Yeah, my daughter ended up becoming a civil engineer,
Mhm.
so it's good. So we kind of can chit chat. I know nothing but science. Yes, I would imagine it is quiet.
On the other hand, we have a lot more neighbors, full-time neighbors than we had a long time ago.
Yeah.
You know, for a long time, we were the only full-time residents for years.
Did they kind of, was it during COVID that people kind of moved up or it's just kind of come along?
The folks just north of me, about 10 years ago. And one big, great, neighbors, and then my son built a house across the road.
Oh,
Yeah, so that's nice to him being there too.
yes.
Takes good care of all of them.
Oh, good, yeah. I wish my mom's over in Conway, so that's like 2.5 hours away. So I ended up going over there every couple of months, usually, just doing chores.
But, yeah, it's, otherwise it's so nice and quiet and peaceful.
Yeah, we were up there with, I think we brought the kids. Hi. Oh, somebody else is online over there. Barry. Barry brought them. See, Braintree person. Barry Rutland.
No, we don't.
Good. I'll have everybody online. Hi, Barry. I'll have you introduce yourself in just a minute when we get started. Just to give us who you are and where you're from.
Okay.
There's still a few minutes left, but the Zoom is going, so mind your manners.
Yeah.
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 So Barry, can you hear us?
Yes, I can.
And can you see the slides? Or do you just see me, or do you see like a slideshow?
I see the first part of the slideshow. Slide 1. Can you hear me okay?
I can, yes.
Good.
Hi.
Yeah. Bring with me and completely forgot it.
Let me see, I'll find it. Ooh.
Yeah. I got one.
Oh, you got it.
Right, right, yeah.
Oh, good.
Yeah, you looked at all of this.
For you?
Very smart.
Yes. Doctor knows. Yeah.
Yeah.
Good. Very. First time.
Yeah, most of the strongest one. Probably, switching to be taking down the.
Just getting started. How's Rufus?
I want to move back on the East Coast. All right. Thanks
Oh
for
my
bringing,
God.
I'm not gonna tell you.
Why? We tried, up and tried. You're down with that. Easy going.
Yeah.
Well, you know what they say about rats. You're not born rats.
That always works. That's when I see this, sort of bring them sort of halfway early.
That's very true. There's a proclivity, I'm sure.
Hi, Linda.
Yes.
And it's week 12, the 14th, this one. November. So I pretty much.
Okay, anybody else out there?
So you did find it. And it didn't come through me.
Yeah, and so like, if I look to my streets, where he was already holding out because of that.
Have you ever had that? No,
I've already seen this around here, that's why
It might be,
we go across the trash trailer.
Yeah.
Across everything. Well.
Are you referring? Well.
Right along,
What
right.
do you know? Beauty there. That way I do all the time. Oh, cool.
Yeah.
Good to know. Oh, yes, you know. Easier. Well, we'll see. Yeah. We're gonna figure out a little bit Good, this is really well. Yeah. We've been all been out. Yeah, yeah. Only missed one, I have to pay.
But when I saw it, I was very.
Yeah. I'm pretty good. Good. Yeah, certainly, oh, that. You're welcome.
This time.
This is time, I think we have a DRB hearing. Oh, like Thursday. No, this, I don't think so. I mean, of course, I always go in thinking it shouldn't be too bad.
The last,
I always get a curveball.
yeah, last one of this I did because they knew they were. Like the lawyers came trained.
Oh, okay.
I think somebody's gonna
Yes.
have a contested hearing.
You multiply one thing, yeah, you go. And then you also.
Okay.
Where is?
All right, I think we're gonna get started. The Zoom is recording, should be recording. And there are 4 people on the Zoom, looks like maybe 3 people. So I'm just gonna ask everybody to just say like your name and your town, and if you have a position, anything like that. That'll help me structure the conversation a little bit. And I'll do me, and then we'll go around the room and I'll call on people on Zoom. So I'm Kevin Geiger, that's me, I'm the chief planner at the Two Rivers Ottaquechee Regional Commission, which is your regional planning commission if you're in Braintree or anywhere kind of south and east of here, all the way to the Connecticut River. And we do a lot of things, I can talk about that a little bit, but the best way to find out everything we do is just go on our website. And then you can see stuff and you can see all the people and you can see how to find me and whatnot. If you have questions, email us. I'm this kind of we call me the chief planner because I used to be a senior planner and then other people are now senior planner and I'm a senior planner. So I went with chief planner. For zoning questions, if you don't get me, Kyle Katz is kind of the next person you'd probably talk to. And then after that, Brian Kovalek would be probably the next person you'd talk to. If it's a flood permit question, me and Kyle Katz and Pete Fellows are all certified flood managers as well. So we have training in dealing with all things flooding. So let's just go around the row. I'm going to start with Jesse here, and then we'll go.
Jesse Broussard, town clerk, treasurer, Braintree.
Great.
CHA development needs to be open. Bob Moyer, chair of the development board for retreat.
Linda John, the open.
Lou Helmuth, Braintree Select Board. Malcolm Fitzpatrick, Planning Commission.
Jackson Evans, planning commission.
Grace Parsons.
Paul Kendall, planning commission.
John Richmond Paul, DRB, Braintree.
Stephen True, the zoning administrator and planning coordinator for South Norwich.
Chelsea Brown, select board member, Braintree.
Megan Uncle, Braintree select board. Karen Freeman, Braintree resident, and I don't, what am I zoning what? You're on the DRB. DRB.
Great. And then I'm gonna, that's good. Well, this is the one, this is the place to be then. And I'm gonna call on people out there. So, Barry, can you introduce yourself?
Surely, I'm Barry Rotman, and I'm a alternate on the Norwich, Vermont DRB.
Excellent. And Ann, I see Ann.
Hi, everybody. I'm Ann Kundig, Pittsfield Select Board.
Hi, Ann. And Craig.
Hi, everybody. Craig Westling, Pittsfield Planning Commission.
Wonderful. And so tonight, we're going to talk about land use decisions. And we're going to talk about them in the general, and then we can get to the specific. If you have a specific question, like a case in front of you, and it's not being litigated, we may get into that or you may have some hypotheticals. If it's in litigation, I'm gonna say, call your lawyer, because that's what you have him for. I am not a lawyer, I pretend to be one on TV, that's the only thing I do. But I always view the law was made by legislators who just wrote the law, and so you should be able to read the law. And tonight, we're largely talking about the state law and what it lets you do in your own law, which are the rules you've made for you. And local land use decisions, really zoning, subdivision, and flood permits, all enabled under Title 24. Those things there. If you have an ordinance, like a noise ordinance or sign ordinance, those may be chapter 59 things, those are a little different over there. And then, of course, if you have some other type of things like a access permit. We have a whole training online on our website about everything else that zoning administrators may come upon that are not zoning permits. Because a lot of other things are there, and they're kind of the point person for the town. So when somebody walks in and says, do I need a driveway permit? Do I need a septic permit? Do I need a wedding permit or whatever? They're often the person who can sort them out and say, not for me, but you need to go over there. Okay, so we're gonna hopefully this will make things go. Yes. And so I'm gonna look at my notes as I go along. And so again, we're gonna make effective decisions. And why is it hard? And it's hard because it's formal. It is not just a chat. Even though it may be your neighbors and your friends and stuff. So you kind of need to bring a little bit of that formality to the situation. You don't need to be rude or anything or impersonal, but you don't want to be overly personal. You wouldn't want to have two people in front of you And you know this person and you have no idea who this person is, and this person's like, hi, and this person's like, like. And then you just go back, because everybody equal under the law, right? Due process, a big thing of me. I grew up as a tot going to the Supreme Court and stuff, and so I think a lot of that stuck in my head. You're gonna be precise. Again, a lot of us aren't precise people in our lives. I'm talking about engineers, precise people, right? This is when you want to bring out your precision a little bit, because you're going to issue a permit to do something. And everybody else needs to go away, and somebody else needs to pick up that piece of paper and go, that the thing that says is the same thing you meant it to say. And you're gonna be doing that with being precise. And you're gonna be decisive, of course, you're gonna issue a decision. It's not gonna be like, well, we think you could, blah, 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 that's not a decision. And none of these things are how we actually decide things, every now and then, and you're gonna have to justify. The law says that you have to write down the reasons, the findings of fact and conclusion of law that led you to make your decisions. I've been doing this 34 years or so. I have seen a lot of decisions at the local level made by somebody coming in, usually somebody and they kind of give you, I want to blah, blah, blah. And people go, yep. And that's the entirety of the decision process, right? It's nice. It certainly is a decision, but it's nothing we can reduce to paper. It's nothing we can go, what was decided? What was okay in that? And so don't be doing that at all, evermore. If that's how you've been doing it. And again, this is not how, if I was gonna say, oh, you should go home and talk to your partner and say what you're gonna have for dinner tomorrow. This is probably not the process to use. But it is in this game, because you are the government. You have the power of the government, and so with that authority comes responsibility to know what you're doing and do it right. That's why you should do it. It is your statutory duty. There's things like that in the law. 4464 is the particular part, Title 24, Chapter 117, 4464. It's just fair. You want to get a reputation as being fair. Probably in life, but certainly on the DRB. Because especially it'll serve you when things get hot. Like, why do you do this? Oh, well, your grandpa, no, you don't want any of those type of things. You want to be bomb proof when you're finished. Again, you're gonna write it so it's understandable to everybody. And it's legally defensible, even though when it goes on appeal, it'll probably be de novo and they look at everything all over again. De novo, meaning look at everything all over again in Latin. The first thing to me you want to think about is, are we the people making the decision? You might get somebody that comes to you wrongly. And thinks you're there to do something that's not your failure. The law created this term appropriate municipal panel about, I don't know, 10 years ago. Because it used to be certain things went to the planning commission, certain things went to the zoning board of adjustment. Now you have DRBs, but they are all AMPs. The administrative officer, the zoning administrator, whatever you want to call that person, they can also make some decisions. And in fact, the law enables them to make some decisions that AMPs make, if your bylaws so provide. And then there are advisory panels out there. Do you have advisory panels? Yeah.
Conservation Commission.
Conservation Commission, okay. Remember, and we see this in regs, those are advisory panels. They have no power whatsoever in Vermont. And they need to get their advisory stuff to the DRB at the DRB hearing. The DRB hearing is not supposed to wait and go, did you get your stuff together yet? Oh, well, we'll postpone our hearing. Nope, we're gonna have a hearing. You get us your advice. Don't have them holding you up or holding the applicant. And they definitely don't have a yay or nay. And they shouldn't have hearings and take testimony and all that stuff. They're advised. Different states, different rules. In New Hampshire, less advisory.
Kevin,
Yes.
that brings something up in my mind. We've never done it. I'm wondering if, when we come up with a case before the DRB, and advertise it and all that, if we should move our conservation commission in on that
It doesn't hurt.
as information at least.
It doesn't hurt, especially if there's. They may be a little bit like subject matter experts about some things, they may have an opinion. If they're not subject matter experts, their opinion doesn't weight than anybody else's. But yeah, you know, because you may have a standard about, like some towns might have a waiver provision. Around, well, we can let you go into the setbacks because you're gonna better preserve a wetland or something.
That's what I'm thinking, in a case like that.
Yeah. Yeah, and that's a great folks to have come in and give you some more.
Or if you have a conservation district.
Yes. Yeah. And I think, with yours, there is some. Does the Conservation Commission come into that process? Advisory in the development envelopes and that type of thing?
You know, on a case by case basis.
Okay.
I mean, we'll invite them, you know, there's clear.
Yep, some folks will have like, a design review body or other type of thing there. Perfectly fine to have advisory panels, important to remind them they are advisory.
Kevin, so if the bylaw does have this advisory panels, what triggers the requirement to ask them their advice?
You would. Typically I would write it in the bylaw and say, you know, you'd have some type of a standard, you might say. Look, the advisory panel can come in on this one, you might just say, everything goes over to them, there's a matter of practice, you know, they just always can comment if they want to. It's important to remember, not to play. For nobody to be playing an expert unless they are an expert. I will see that sometimes like on traffic. People will go, well, that's, you know, that's gonna be too much traffic on the road. And you go, are you a traffic engineer? Probably not. So especially if you have a traffic engineer over here going, no. You're not a traffic engineer over here. Don't be fighting with the traffic engineer. Sometimes you'll get dueling, you may get in Norwich, you'll get dueling experts and that's fine. You know, you'll have a wetland biologist go, well, this is the thing, and the neighbor will have a wetland biologist going, that's not the thing. And then it's gonna be up to you to decide some stuff, and we're gonna get into it. So first off, make sure it's actually should be in front of you. The advisory bodies, again, because there are a few towns that have advisory bodies and a few towns who need to straighten out that they're out there helping. When you make a decision, application is complete, everything is gathered. So this is important. So you can have it all sorts of ways. You can say, we're gonna rotate in the DRB, we're gonna have clerk of the DRB, we're gonna have the zoning administrator kind of be our staff on the DRB. In Norris, we have Stephen, to say, okay, is this thing, because you're gonna go to a hearing, right? You don't wanna have to drive to the hearing on the snowy night and go, oh, well, they forgot the map that they had to give us or whatever. So have somebody say this thing is complete. From a zoning administrator's point of view, it is not a complete application because it doesn't have key approval, but it's complete enough to go to hearing. It's got all the pieces. And if it doesn't, send it back. My advice to towns is always an application fee is not a permit fee, it's a fee to apply. And if they give you bad applications, deny, keep the fee, send them back. they will get the point eventually and stop paying you and do a decent application. It's important to note as the ZA, when an application is fully complete, so you get something on your desk, you go. Complete except for DRB approval. Over there to DRB. DRB deals with it, then once it's complete, it comes back to you, now your 30-day clock is running, you've got to get that from down. At the hearing, you want to make sure every piece of information is there. And this is the critical part, and basically you're the jury. And when you go off. The kind of, think of like the information getting sealed. You don't get to. You can, but it's a mess. You don't really get to come back because everybody in the process gets notice of the whole process. So then you'd have to notify the world and stuff. But once the application is complete, and so it's important to think about if you have a standard. And you know, let's say you're dealing with a conditional use. And you've got the 5 mandatory standards, and then you've got some other standards. And you just go down them and go, well, you know, we're supposed landscaping and screening, traffic and circulation, whatever the things are. Do we have enough to make a finding on that? And as the chair, who's the chair of the DRB? So as the chair, what you're gonna do is you're gonna go, we all, everybody ready? Do you have any unanswered questions? And then you're not gonna go, okay. You're gonna go, are we ready? Are we ready? You ready? You're ready. Very good. You're gonna give a little bit of time, right? Then we're gonna go off. It helps to have the standards right in front of you. So you can kind of like basically go to Word and copy out. And make like little checklists or whatever, and go, this is how we're going. And there may be things that don't apply, you know. This is well, this whole site's a parking lot, no lines. But. It's not, don't have the applicant necessarily go, well, that doesn't apply. You're gonna need to find that it doesn't. Versus like, oh, I don't know what they're doing. Guess that doesn't apply. So that's important, make sure everything is known. That's gonna be known. Yes,
Potentially 2 questions. So the application being complete and all information gathered, are they one in the same?
hopefully, yes. But you're having a hearing, otherwise you just mail it in and wouldn't have a hearing. And so there's gonna be things in the hearing or in a site visit. Where you're trying to gather more, and there are gonna be questions like, well, we just got in, for example, a cell tower application. The other day. And it has a whole bunch of pages because the drivers. And on this page, it shows us the edge of the tree line. And it just says tree line. This page, it shows us existing tree line and proposed tree line. We're like, different legend, there's no existing and proposed, is this existing or proposed? That type of thing, it may come in, you may say, well, this is complete, and only in the hearing you go. Wait, where's existing, I want to see existing and proposed, and you guys throw a power line going through the woods here. But you don't show that they're gonna cut in trees, and I'm pretty sure they're gonna cut trees. So, you know, all those things might come out in here. And your AMP is making, you're making judgment calls, but they're not crazy judgment. Right, that's why we have juries, they make judgment calls, but they make reasonable tests of judgment. And so you may have, especially on landscaping and screening, there's often a minimized visual impact, or things like that. And you go, does that mean a brick wall? You can't see it forever, 20 feet high? Or does that mean like 1 arborvitae? It's kind of off to the left, you know, that's not even in the right way here. And so you're gonna have to decide those things. Question. And you have time frames. The most important time frame, and in fact, there's a new time frame now that I don't know off the top of my head. But it's what's it?
120 days.
120 days from time of,
From when an application is complete, if we're talking about the same thing.
yes, yes,
When an application is completely presented to the DRB, but for them to take action.
okay, good. Yeah, because it used to be, there's a time frame from your final hearing to issue a decision, but there was no time frame to get to there. And so the legislature said, okay, we're gonna make you get there. Now, that's a complete, so again, they get to your hearing, and you're like, you don't have this thing, go away. Who's ever taking the notes of that, make sure you kind of go. This is not complete. This is not the final hearing. As the chair. If you have a hearing, you've got to notice any people who want to play or have the hearing. You don't need to renotice the hearing. If we're all going to a time and date certain. Applicant, when can you give this? Next Thursday, great. We're all gonna meet here next Thursday, 7 o'clock. Everybody in the room hears that, everybody in Zoom hears that. If somebody has sent you a letter testifying, I would let them know. Otherwise, though, we don't need to put anything in the paper going, we're all gonna meet next Thursday at 7. And say this isn't the final hearing, we're just adjourning this hearing. If they're like, I have no idea what my landscaping. Oh, we're gonna close our hearing. This is not the final hearing. Make sure we're gonna say that. The applicant better get us this stuff. Some bylaws will say, if they don't give you what they need in 60 days, it's denied, goes away, it's not the process. I think it's kind of nice to just make it not like forever. To give them some type of time frame to get that. But you're right, so now 120 days from all the pieces apparently in. You gotta have a hearing. When you have your final hearing and you close the door, then you have 45 days to issue your decision. We'll talk about decisions a lot. Where do you make it? I always advise bodies to make them in deliberations with your body. These are not executive session. They're a different thing in the law. And you can do them in public. There's nothing that prohibits you from doing them in public. My advice is to always deliberate in private, even if you're 5 minutes. Because when it gets hairy, people are gonna go, why are you going off in the back room? Because you're sleeping. And you go, no, because we always go off. And everybody will remember that, and they're like, yeah, that's what they do. I've seen them do it that way all the time. I don't know why they do it, but that's what they do. But you're late and able to do that, and it's a deliberation, and again, think of it like the jury, you're gonna go off there. And you get to decide, yes.
When the DRB deliberates, can they invite people to participate in their deliberation with them?
Very good question. No. It's basically the answer. With some exceptions. Yes. But the best way to think of it is no new testimony is entered because the people who were able to go to the hearings aren't there to hear that new piece. So that universe of potentially interested parties is now shut out a little bit of the process. But I've been asked by towns, for example, to go to the deliberations. You might have a subject matter expert, I suppose, do that, but you don't want to be in there kind of going, well, this wetland map, real, this is crappy, no, right? Fred, you're a wetland expert, come in, like, isn't this crappy? Yeah, like that wouldn't be good. Something that is to me, a kind of it's not an opinion. It might be, like, it's usually a process question. Like somebody says, wait, do we have to issue a decision in 45 days? You go, yeah, like you, all of a sudden, I would tell you that, yes, you do. they might say, I suppose somebody might say something about some other process or some other bit of law, and certainly you might have a lawyer on their side. And talk about that. Oftentimes the ZA or who's ever writing the decision is often there. To help draft the decision. Stephen probably does that.
Just to make it fair, you're saying all deliberations are open to the public?
They can be. My advice is to always do them in private. The law enables you to do them in private. My advice is always do them that way, even if you really don't need to, even if it's just. Like, it's obvious. Just because then you build that pattern and people don't get. Thinking you're weird when you do that, you go off.
So but you can legally do them all in private?
Yeah, yes.
We've had an occasion once in a while where it's pretty obvious, but we've had the applicant step out of the room. We looked at each other. Yeah, we're all agreed on this and could call him back in 5 minutes, like give him a verbal okay, but
Right. But you won't be doing that because you won't have a written decision. You might be like. I suppose you might be like, we're probably gonna issue this, but until you have a written decision, because then you go, well, what did we approve? And unless you've written it down, it's hard to know.
well, this is usually a very simple matter, but we also make it clear. It looks like we're going to give you an approval on this, but you'll get the written decision with the details.
Because other people are gonna get a copy of that written decision. And the decision, remember, has to include the findings of fact and conclusions of law. It has to say why you got to the decision you got. So it can't just be the yes part, it has to be no, because therefore, yes. And that's hard to come up with, like, just right off the top of your head. Talking about. You are allowed by law to use the minutes of your meeting as the decision. My advice is never. Because provided minutes usually aren't good enough. And you have to approve minutes, so it's very unclear, like, well, we didn't have enough quorum to approve the minutes, and the 45-day clock ran out. What happened? So my advice is always write it down.
So if you do it.
Yeah.
I mean, and sometimes I've used, minutes quite a lot. Do they have to be approved before they're final? Or is that just a question, potential question?
To me, I don't know, I mean, minutes are always drafted and they always get approved, I figure people are approving them for some reason.
Well, yeah, maybe I'm asking the question incorrectly. If you, for some reason, you don't approve, but you make a motion.
Right.
Conditions or no conditions, it's on the records.
Yeah.
But is that motion not valid?
Without you select word, if you were to get a resolution to do something, buy a parcel of land. Or do something on the bank. And you went to the bank with a resolution and said draft on it. Would they be like, yeah, come back when this resolution is not happening? I think the answer is yes. And so, yeah, I don't think it's gonna hold unless it's approved, because somebody might go, wait, that's not actually what we decided.
Yeah.
So I urge you not to use the minutes. Deliberations, I think I have my deliberations little statute here, yeah, you can't read that, but, this basically says we can do deliberations. And the written decision need not be adopted at an open meeting if the decision will be open. So the decision is coming out there, but how you actually, got to that decision, I don't believe, and this is a good one for your attorney, but I don't believe that vote is actually a public record. The decision is a public record. Again, just like the jury, you don't go like, wait, what did Fred vote on that during the jury? Like, well, because it's either a yes, you get to do it, or no, you don't.
Yeah, but
And there is no dissent from.
Is it clear
that the written decision is signed by all the members of the DRB, or who signs it? It says that this is what we all agree to.
I would just have the chair sign it. If it's a subdivision, some towns require certain people to sign the plat.
Oh, but again, if it's just the chair
Yeah.
sign, why can't the other members say that's not what we agreed to?
Well, if.
No, really?
Yes, well, that's why, to me, if you're gonna do the minutes, it gets a little weirder. If you're gonna do the written decision, they are all there, like you're gonna hand this thing around. We're all gonna read this thing, and we're gonna go, all in favor of this decision, say aye, aye.
Okay, so that is, so the approval of the decision is made at a regular meeting.
Note to me, you can do it in deliberations, but you're gonna physically have that thing. And that's why I always want you to look at it. No decision is, to me, a decision unless it's in writing. It has all the pieces. And that's why it's gonna be very hard to take that out, lickety split the night of the hearing. If it's an easy one, ZA's, Norwich, some other places may do this, is they essentially pre-write the decision. They look at all the application material and they're like, oh, yeah, this one, I don't know, yeah. And they kind of fill in all the blanks, and then there's just a couple of things at the hearing that they need to do, and so they can get a kind of a draft decision really almost ready. So it's not a great long time until they have in right. I doubt that a lot of times, you're meeting and it's 9 o'clock or 10 o'clock or something crazy, I don't know. Let's type this thing out and look at it. Plus, you're blurry. What? Go off, get a good night's sleep, come back. You can be like, we're gonna meet at 8 in the morning for coffee. Over there. And then we'll decide this thing, and we'll all have this thing in front of us. So really make sure it's in writing. I see a lot of things like. In fact, we're not party to local decisions, so I'm not usually in the room, but I am often like going out and meeting with towns. And before I meet with somebody, sometimes before I meet with DRBs or planning commissions, or especially if you're wearing both hats, on the same night, you're watching an action. And then they'll be like, yeah, pretty good, okay, we'll write that out, and then, and you go. Yes, and we'll write that up. Not good, because what did you say yes to? Did you have a question? No. What's the decision about? What the applicant wants to do, they have to figure that out, not really your job to figure it out. Sometimes applicants kind of like, well, what do you want us to do? You tell us, we're not gonna leave you on. Can you do it, and how they will have to get it? This is kind of your bylaw, and this are the standards, and there may be some timing in there and some other things. But it's gonna talk about all those things out there, and just because they wanna do it, that's not a reason for them to get a permit. So a lot of people, there is an overwhelming, this is just a psychological thing. Is people want certain things to happen. And then there are standards and precision and things that we. And sometimes they just kind of like smush these together in their brain. And it's your job to go, wait a minute. You want this, but you want to put in 46 in the restaurant, but our bylaw requires 60. But you want 40. Why can't I get 40? Because our bylaw requires 60. But I want 40. Yeah, but the bylaw requires 60. And sometimes you're just like, it's like you're not connected. And so do not underestimate the power of what people want versus the actual rules. And if any of you know how to like do magic with that, let me know. I'm constantly running into them. Again, forms, you could make a form, you can have your application form, but then you can have kind of a decision form where you have a bunch of checklists and your standards all written down. And you go check, if it does not apply, or maybe a little comment from there. And again, I think having the ZA, whoever you're gonna have as staffish type person, is advisable. And this is where, to me, this is where the friendly part really comes in. Is because there are a lot of people who don't know exactly what they wanna do, and they don't read zoning bylaws like we do for our lives. I don't, you're not crazy, you don't, Steven does. We call us people civilians in my, that's what I call them. Or I call them normal people, and then they're like people planners. But they don't know, right? And so they're gonna come in like, I wanna build a shed. You might go, big is the shed? It's 12 feet by 12 feet, 10 feet high. Oh, great. I don't know how big the shed is. Well, what's this? The shed's 30 feet by 30 feet. That's not a shed. You know, there may be things in there. We see tiny homes. People are like, it's a tiny home. I don't care if it's minuscule. It's a house or not a house. But it's tiny, yeah. And again, not a thing. There's no place in the law that says tiny homes over here. There are places where you may advise people, and again, this is where it's good for ZAs to know a lot of the stuff out there. Because all non-owner occupied, single family homes require state building permits, which aren't in your regulations at all. And I've had people coming up and like, I just had to get a state building permit, the town didn't tell me, like a non-town permit. But when I'm building my stairs like this in the tiny home that aren't to code, and then I'm gonna rent my tiny home, ain't gonna happen because I didn't build a state building. And again, there's nothing in your zoning that talks about how steep the stairs are. Pretty sure. And then there's other things, like where I'm gonna build a shed, where are you gonna build it? Oh, right next to the river. Or maybe in floodways. I'm just gonna remodel my house, I'm just doing inside the four walls. Most zoning bylaws would say interior modifications, no permit needed, right? Oh, except I'm in the flood zone, and I'm gutting the house, and now it's a substantial improvement. Oh, you're gonna be jacking your house 5 feet when we get done with it. Oh. I'm glad you told me now when we were having this discussion versus later. Oh, I'm taking off all the siding outside the building. Oh, fine, we don't care, you don't need a zoning permit for that, but since you're removing the sheathing on the outside, you're removing the drywall on the inside, you're doing one of those things. Your work is going to have to be compliant with the residential building energy standards, because state law requires that. And it requires me to give you a copy of the ordinance. But you're not gonna need a local permit, yes.
So if our bylaws don't say anything about what the state laws are.
Yeah.
Then how does the state find out about it and who cares?
Right. Good question. It's not up to you to be the police for the state. That's not for us. Sometimes we see egregious examples and we will follow this there and be like, you should check that one. Unpermitted landfills, things, big piles of burning stuff, other stuff like that, or like, yeah, I'm pretty sure they don't have a permit. Sometimes towns ask us to get involved in these things, so we're glad to make them. Folks in my, but yes, oftentimes it's not. It's just kind of a courtesy thing because they're like somehow thinks Stephen knows everything. Or everything about everything. And you didn't tell me that I needed to do that thing because you have that certification that they did something in accordance with the energy standards gets filed in the town limit. So they don't file it, nobody certified it. Not a zoning violation unless it was something involving the zoning bill. And then if you have a certificate of occupancy. So if you have a certificate of occupancy, you are required by law to get the certification that it meets the energy standard. That's one of those movers of. So there are a couple places like that where the state is well reviewed to their process. Other places, not so much.
I've also seen on some building permits, zoning permit applications, the statement, all. This permit is conditional on receipt of state and or federal.
Yeah.
Permits as required.
Yeah.
That's a pretty good way to get the conversation.
Ours does say that.
Yeah.
but, I mean,
In terms of enforcement, yeah, it's fine, but, yeah, you can at least tell them. They continue to work.
Yeah, and it is one way, not so much to make the state do their job, but if the state wasn't doing their job to go, oh. You got a state, you got for example, a wetlands permit, and you did not do the thing in the wetlands plan. That also makes now local zoning violation, and we're gonna put down there. While we wait for the state wetlands to make that. A lot of times. I mean, there are some things where the state folks will take a while, but a lot of times the state will get right on it. Especially if you start with CC the secretary. Somebody. And they'll make sure that it happens.
now, also on your forms, these forms
Yeah.
that make good applications and so on, who should be in charge of putting those forms together? How do you get that ball rolling?
I would have, I would have the zoning administrator probably do them. Unless you have somebody that acts like the clerk of the AMP. Or something like that. If we're actively working on the regs reviews, we can probably do them. We never really had executive flood stuff. Don't put them in your bylaws. Every now and then I see some like one in the bylaw. Don't put fees in your bylaw. Select board sets the fees for applications. Not in the bylaw technical. And then, because then you can always, oops, our form's bad, but we'll make a new form. It's not like stuck in. Any type of special powers to change it. Standards, again, everything is gonna be about a standard. And this is the hard part, I find, and I'll walk you through this a little bit, because to me, this logic is a critical thing. There's one thing, well, besides like write it down. The takeaway tonight, you're gonna think about evidence, testimony, fact. And making those things. But what are they applying for? They're applying for a house, a duplex, a shed, renovation of the house, whatever. And that's gonna come under this part of the law. Oops, yep, we see that. It's listed as a conditional use in table 3.2. They can do it in the district. We've checked the district. Again, sometimes people ask you, well, back up. The only person, and I mean the only one, that responds to questions about, do I need a permit for this? Is. Right. Select board, never ever, you're pumping gas, and federal government, do I need a permit for this? And you go, I have no idea, that's what I'm just doing. Talk about anything else. Don't go, sir, I think so. Bad. Camping, no, none of you, zoning administrator. Because if they get it wrong, that's the problem, but that's their job. So what district am I in? A lot of you will have clauses, sometimes they're in 2 districts, sometimes it's hard to tell. But usually you know what district you're in, what are they trying to do, then what standards apply, oh. You're this, oh, now we need site plan standards, oh, we need conditional use standards too, so you put these things and these things. And that's where the zoning industry is really great, it's like, oh, you're on page 12 here, we look at the map, you're in this district. And that page and these things, those are what we're gonna make you put standards. So there's not surprises. Hearing, again, you're gonna put people under oath, they're testifying. Oftentimes people don't do that, like, oh, I don't know, well, we're gonna put you under oath. I boiled the hearings down to here, that's why they're called here. Listen to what they're saying. Hear anybody else. Remind them, if you wanna be an interested party, you have to participate in the hearing. Sitting there grumpily is not participating. Maybe going, I don't like it, maybe that's participating, but they need to do something. People who aren't there, they're in Florida, and they wanna write you a letter, fine. I would read the letter, so you can't be like, whoa, we got a letter. That's interesting. Oh, I never thought about that. Those letters, like nobody else knows what's going on, right? Read the letter out loud. Now everybody knows what that letter is, put it in the record. Hear your own board. Especially the quiet. I am not a quiet, as you can tell. So I'm gonna be over there like, ooh, I have a question, right? But there's some people on your board who are quiet. And then later they're like, I really wanted to know about the defense thing. You will know those people, and so you're gonna be like, everybody good? They each set the standard, and give people time, so that they can speak up, we're gonna close this thing down. Yes.
Who can be an interested party?
The law has a test for interested parties. My advice to AMPs is let everybody in. You could be like, you're not an interested party. You're like, you can see the thing from across the valley, but you know, it's minuscule. No. They're like, fine. I'm gonna appeal. That act. We all stop. 3.5 years later, we will get an opinion whether or not I'm an interested party. Meanwhile, applicant is going crazy with everything. So my advice is let them all in the door. And then if they, for whatever reason, if they don't get it, and then they want to appeal, then the court can sort them. And can say, well, no, you're not.
The court decides that the municipal panel doesn't determine party status.
They shouldn't, and if they do, it's an appealable act. The ZA, everything that the ZA does is an appealable act. And
Glad to hear you say that. My impulse is if somebody cares enough to show up and want some input, I would pretty much consider them an interested party and let them give their input. And if it turns out to be irrelevant, you let them say their piece if they haven't done any harm. But if they've presented something that is pertinent, you can take them into consideration.
yeah, and as chair, you're gonna keep it polite and germane and stuff.
Right.
No personal attacks, obviously. From the review body especially, no personal stuff, because you will get in court. And you'll be civilly, personally sued for being a bad person, versus enjoying your sovereign immunity over here in a nice job. And I've seen that, like, you know, well, so-and-so, you lied to my mother, whatever the crazy thing is, and you're like, no. I don't care if the person is Mother Teresa or like whatever bad person you can think of over here, they get treated exactly the same. And I mean exactly the same. Because that's what the Constitution requires, amongst other things, but it will also give you this reputation as being fair. So even the people who don't like you, they're like, I don't like him, but he's fair. But that's really important. Here. Okay, let's see, there's one other thing we're gonna get to. Oh, what happens if you goof? Commonly done. Oh, we closed the hearing and then we forgot to ask, they forgot to tell, somebody forgot to do something. My advice is just be like, okay, tell the applicant, especially if it's your fault, tell the applicant, oh, we forgot. We will eat the notice requirement, we'll renotice in the paper. Because we can't just kind of have you all come back, because we didn't have the time to be certain. We're gonna renotice it and just open this thing back up again. And then we just hopefully deal with that one more thing and then go back to the business. But that's the cleanest thing, and that often. If you do something wrong, if your hearing notice is wrong. If you don't have a quorum. All sorts of things happen, just, redo things until it's right. Because you want your process to be good.
If the meeting gets reopened, does the 145 days start when the first meeting ended or when the reopened meeting ended?
That's a good question, and I don't know, like, yeah, was that a complete thing? And the 120 days start, it'll be interesting to see, because somebody eventually in the court case will go, what do we mean by complete?
Yeah.
Do we mean like we thought it was complete, but then we went to the hearing and it wasn't, or? Somehow, they actually said. It was complete, but it's, the law says, we have to have our hearing. Within 120 days after it's complete, so somehow over here, we gotta figure out the completeness. And we haven't met yet. How do we do that? You go, that's. Why my hair's short. That's the legislature did that.
Yeah, I mean, I think the intent there was so DRBs don't, I don't know if this really actually happens, but you can't slow roll an application.
Yeah, I understand that. I was just curious if what you're saying is like if a board decided they made a mistake, but the meeting had already been closed.
Yeah.
And it gets reopened. I just wasn't sure which
It's
which
probably,
date counted.
it's probably the second date. I mean, you
Right.
close the hearing and then you reopen it.
Yeah.
Same,
I would chug along, I wouldn't. And again, yes, always, you don't wanna be just kind of. Playing people in some way, shape or form. Cause again, that's your reputation, word gets known. But you're gonna, okay, you've held your hearing. And now you gotta decide. You're gonna have deliberations in writing. With a clear introduction, I'll talk about these things a little bit. Findings of fact and conclusions of law and a summary decision. You kind of write all those little pieces out there. Back on the hearing part. It's easy to think about making a finding of fact when you have contested things, and you have to decide. The best way is to think of everything as contested as you go. And for whatever reason, I always use a visual screen. Because a lot of people in their bylaws have some standard around landscape and visual screen. And it might say, minimize the visual impact and see from the public. And the applicant comes in and they say, oh, yeah, I'm gonna build the whatever back there and you will not, it's kind of behind the hill and there's a tree in front, you just can't see it from the public way. You're like, okay, good, that's sense, yeah. And you go up to here. What they have done is they have told you a thing, you have some evidence and testimony, but you don't know if it's true. But lacking anybody else in the room, you kind of do a thing and you go, fact. So now over here, applicant says you can't see it from the road, we find you can't see it from the road, which is meets our standard over here. We have now made a fact and had a conclusion of law based upon that fact that we made in our mind. It's much easier to see that process out when you go, the neighbor goes up and Henry says, everybody can see this. I can see, the entire property every time I drive by. You couldn't hide a gopher on this property, without me seeing it. And then now you have to be like, uh-oh, we have to make a decision. Maybe we're gonna go out, maybe we're gonna have a photo, maybe we're gonna do something. But without that second piece, you never kind of do that fact making part of your mind, you just do it. And that's the most important part, because that's where you're going, well, what's a finding of fact? Finding of fact is taking that testimony and going, we believe that, now we find it to be true. Now we've made it a fact for our purposes, now we can give meaning to that fact against the standards and make it approved. And so is everybody clear on that process? Because it's something we just do. Especially if the person is somebody we know and trust. We go over here and we do it so fast, we can't even write that down. But, so I try to think about things as. Like, maybe they're lying. Maybe they're not. Not that they're bad people, it's just like, maybe they didn't read the standards, right. Maybe they didn't. I've been in Act 250 cases where I have professionals showing me mock-ups of buildings. And going, you can't see the building because the tree's in the way. And they've staked down where the building is over there, and the tree that's in the way is over here. And I'm like, so that tree is gonna block that building? And the architect goes, yes, and I'm like. Go stand where the building is. Now I'll see if the tree blocks you, you know, or whatever, and you're like, clearly it does. That brings me to site visits. Site visits are really good. Site visits are not testimony. You don't make decisions at site visits and stuff, but they are really good for kind of going, if somebody's got a tree that's gonna block something, or they have a cut line, or there's a road, or there's a stone wall, there's something on the site plan and you're trying to figure out, is this the thing you're showing? Is that tree there, this tree here? And you're trying to understand the situation. It's really good for those type of things. That are physically on site. You don't have to do them. But you've got to notice them if you're gonna do them. So again, you're gonna go off and you're gonna make the deliberations in private. If you would, in writing, always. And, to me, you kind of do these parts, I would say, you know. Try to apply to do a pizza parlor in the commercial zone. We approved it. And then, you know, who did what, when, where, what were the basic issues, and then you're gonna go into. This is the standard, blah, 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 as you go along, and so to me, this is the kind of, you know, on this date, so to apply for such and such and such and such, and we come here, well, we issue a decision, the project is this. In this district, so these standards. And you know, and then once you kind of get one. You can reuse it for very similar cases as you go along. That's the nice thing about computers, like we can save all that stuff now. Using over and over and over again. I should mention. Yeah. Yeah. Writing 45 days. Turning things into fact. I should mention that, this one. Sometimes you're stumped. You have a standard. Which you thought was a good standard. I've written. People come to me, what's the standard? I wrote that, I don't know. Now, you know, I wrote it 20 years ago, I thought it was good then, but it clearly is not. If your standard is considered, get a new standard. I don't know your bylaw. I don't know.
Can you expand on that a little bit?
Yeah, I see a lot of bylaws. It says the DRB will consider the project's impact on wetlands, visual impact. And I just picture a bunch of people rubbing their chins, you know, we're considering it. Okay, we considered it. And you go, that didn't mean anything, it didn't mean, are we supposed to consider that it's good, or it's bad? Or it doesn't give you a direction. So don't have to consider it. Try not to have the words possible. Because things are possible or impossible. Impossible is impossible. If I spend $1 trillion and can do it, it's not impossible. It's just very, very expensive. So we love the words reasonable because courts use the words reasonable. We love the words minimums. Again, we can take a bunch of people and we can go, is that a reasonable attempt to minimize it? And you go, but you know, reasonable, we'll see it like with forest stuff. Applicant will make a reasonable attempt to not go and parse, you know, cut up the middle of the forest. And they've gone and put that right in the middle, no, not reasonable. Now I'm here, well, you know, we may go, well, is that too far into this? We can all agree this thing wasn't reasonable. So that's what your standards should look like. They should be, applicant will demonstrate that traffic and circulation are safe. That the visual impact is minimized from the road. Sometimes you'll see from adjacent properties, and you go, well, my property abuts that hill. Adjacent, I can see it technically across the valley, but is that what we meant? So try to play those things. But if you get in a pickle with a standard and go. We don't know that word. means. Appurtenant, by the way. The legislature has said accessory dwelling units that are appurtenant to the principal structure on the property. You get to have in Vermont. Why they did that, I don't know. It can be inside, attached to, or appurtenant, meaning nearby-ish. But why didn't they say within 50 feet or something? And now we all get to guess like what appurtenant means.
Great.
It is. Yeah, they're like, you know, we need a 12-letter word that means near. Why don't we just say near? Why don't we say within 25 feet? Oh, perfect.
Because they couldn't agree on the distance.
Right, because they couldn't agree on this. Well, but now you get to go, is this appurtenant or not?
You'll see what happens.
Right, you know,
And somebody will complain and then
like 100 feet, you can always make the rules looser on ADUs, for example, and other things. But you just can't make them tighter. Site plans, by the way, there are no required standards for site plan review. You can make up your own. Law clearly says make up your own. Conditional use, you have a 5-part test, you have to use the 5-part test, and then you can make your own and stick them on. If you have site plan and conditional, which many towns do, my advice is you make them one process. By a clause in your bylaw that says, if something needs conditional use and site plan, the conditional use process will suck in the site plan standards and they'll give you one decision. And will be conditional use or the other way around, but I like site plan to be able to read the conditional use. I say that because potentially you are issuing a site plan approval and a conditional use approval. 2 hearings, 2 decisions, same body. Some towns, different bodies. They still have the planning commission and the zoning board of adjustment. Some towns, different bodies, same people. One bunch of people, 2 different hats, 2 different bodies and 2 different hearings. So I gotta warn the hearing is both and then issue decisions is both, even though we're same people in the same room. And you can see like, just stick all those things together. That is where, to me, kind of cleaning up the rules can help you over here. Maybe. It's not crazy. And that's why clear standards, again, consider no possible, no practical, no reasonable, yes. Because you want to be able to go through the process and understand what I mean. We've talked about that. This is the law and decisions 4464. Close the evidence promptly after you've got everything. During the hearing, remember, you did never make a decision in a hearing. Hearings are hearings. Whatever you're doing is a body, you don't make a decision in the hearing. You make a decision in a meeting, or in this case, in your deliberations. You have 45 days to get that. It shall be issued writing and shall include a statement of the factual basis. Get to your conclusions and a statement of the conclusion. And so that's the law, so you have to do that. And so that's why it's of course you're doing that. Again, the meetings may suffice, provided the factual basis and conclusions are in there. Generally, facts and standards equals compliance. That's the therefore part. And again, our brains don't work that way usually, but it's like, oh, they want to build a pizza parlor. Pizza parlors are an allowed use in that district. therefore we find you can have a pizza party. As it's in that district, we'll state that 25 feet from the lot lines are standard for setback. They say they're 25 feet, we find that they will be 25 feet, therefore, they comply with the setback. Think about it that way, and then the conclusion is, they got a permit. Approved or they're denied. And again, that's the end of the show, a little bit, we'll take lots of questions from people out there, on Zoom. If you have questions, you can like literally raise your hand in a second here. Every planner in our office has the statute. And every year the legislature changes something, and so we have to throw this away and buy a new one. But we read it, and I've been doing this a long time, and there are still parts wrong with it. And so the thing that I do when I get a question is I often pop this open and look at it. You should do the same. It's a procedural question. If it's a course of bylaw question, you crack the bylaw and you look at it. Whenever you call me in towns, call me. Grace is good. Feel free to call me. A lot of times calling me is the answer. What about this? But the first thing I do is I read your bylaw right in front of you. I'm really fast at it. And go, oh, well, I see that this is the thing right here. And is there a way around? Somebody just asked me a question about going around something the other day. I said, nope, don't see. But you know, I try to be helpful. You should try to be helpful. And a lot of times when an applicant, I'll be like, oh, well, we could have gone to this thing. Ask us. This is us. The Secretary of State is a good person, and League of Cities and Towns, of course, in the lawyer. About process questions, what does the law mean, and that type of stuff out there. But feel free to call. We do this for a living. You pay us to do this for a living. So we think about this in all the time. If it's one of those gray areas and you're like, oh, we didn't say what a fence was. Well, we all think we know what a fence is, but what about a berm? Berm a fence? And I say this because we have people who do this in the region, they're like, it's not a fence, I just built a giant mound along the edge of my property. But it's just dirt, you know, well, it kind of works like a fence. So we're gonna call those things fences. So from then on, you're gonna call those things fences. You know, if you make kind of a precedent decision, write it down, stick it in your bylaw. Next time you revise in your bylaw, say fences, farms, other things that actually fences. There's a lot of antagonists. Spiked fences. Any of you have a spike fence case in your town? Oh, those are joys. Where somebody's like, I'm gonna build an 8-foot fence right here next to you. So those spike fences, which is why if we're writing a bylaw, we'll often say fences 5 feet or less, different rules than fences 5 feet or greater. We had a good case over in Fairleigh, Thetford, where they put like telephone poles and basically built like a drive. That was obviously not a good idea. And then de minimis. I think your bylaw probably has, always have a good section in the beginning that says these things don't need permits. Because you also have a part that says anything this bylaw doesn't say can get a permit, can't get a permit, it's prohibited. So you want to make sure that you have this little clause for the realtor sign, bird bags, you know, tree houses, whatever. And we get calls on those. It's tough because sometimes you give those, you know, bird bags, and you go, okay, bird bags. And then they build a 40-foot bird bag, and you go, oh, I didn't hear. And I always bring up the Brontosaurus in Texas. Close notes. Because somebody built a driftwood life scale Brontosaurus. That's kind of a long one, you know, yeah, that kind of. Well, the best thing is de minimis. ZA gets to say that's de minimis. That's an appealable decision, but all sorts of things fall in there like, no, I'm gonna park the roll off on my front lawn. Okay. Don't even jump on it. It's been there 6 years. Like, yeah, it's like a structure. We see a lot now with a shipping container, it's kind of like a garage, it's gonna be there a little bit. Is there like a year less, we care, more than a year? All that type of stuff. But questions, any questions that you have that you, hypothetical questions? Questions that you are not getting litigated on? Things that have always bothered you and you're curious about?
What's your take on separate hearings for sort of sketch plan reviews, preliminary plats, final plats?
This is under subdivision. Yeah. Ranking subdivision, I can't remember. You have subdivision bylaws? You have unified bylaws, subdivision? I think, I don't like minor major. A lot of bylaws have minor process,
Yeah.
major process, because really the impacts might be much more than whether it's a 3 lot or a 6 lot. It may have to do more with where the lot lines are going. So I don't like minor major. Preliminary, the issue with preliminary meetings is they're usually nothing they say is binding on them, nothing you say is binding. It's just like a get together. To me, I'm like, just to get together. Meet with the ZA, go over the rules, nothing's gonna be binding anyways. It's really to familiarize the applicant with everything that's gonna be on it. If there's gonna be a question about, oh, we're gonna wanna see X on hearing time. That should be a knowable thing ahead of time, the rules should be like, and here. Waivers under zoning are different than waiving things under subdivision. The legislature uses the same word. But you're enabled under subdivision to waive any and all requirements. And it doesn't even say particularly why. But you can be like, that doesn't apply. Write down why. But that's where I guess that sometimes a preliminary hearing might be. Oh, do I have to survey? In fact, this was one recent town comment. I got 100 and some acre property, they're chopping off like 2 acres, do they have to survey the whole thing? I'm like, no. Why? Different than they got a 4 acre property, they're subdividing 2 acres. And this is a 2 acre lot, and I gotta know, I got 1 2 acre and another 2 acre. So it's not even gonna be even close, it's gonna be dead on, yeah, you're gonna have to survey. That type of thing. A lot of bylaws say it's at the applicant's request, that they can skip it. Which is kind of nice, because they can be like, I got it, I'm gonna forge ahead. And then if they're like, oh, I didn't have it all, it was their own dang fault. That they're trying to figure out. Then you have oftentimes a preliminary approval and then a final approval. It is nice to me to have something that says, this is approved, now go make the Mylar. Because that's gonna be expensive to get the Mylar made and signed by the engineer, and then come back to us. And then we will formally approve this thing. And get that.
Yeah, I mean, I've seen a number of different approaches, where there's, like a sketch plan review, which is, I believe, the non-binding sort of conversation. I'd like to eliminate that.
Yeah.
But if you open a hearing for preliminary plat review,
Yeah.
that's
kind of
on
like,
the record. So,
yes, and that's kind of like the hearing, that's really where the meat goes on.
yeah,
Because final, if you have a final hearing, it's really like almost pro forma at that point. Like, oh, you did everything you should have.
Yeah.
We're going. Yeah. Subdivision, I think for a rural town, subdivision is probably more even important than the zoning. Because it's where a lot of the thing, it's where the, the horse gets out of the barn, in terms of. Oh, I'm gonna build my house in the middle of the forest. Well, if I have one lot. And I just have to be 25 feet setback, well, all sorts of here. Oh, I subdivided a lot. And you let them subdivide the lot in the middle of the forest, well, clearly now they're gonna build the house again. So that, in that process of going, oh, no. You can have one there, you're gonna have a lot over here. It's where those things, ag fields as well. Not gonna make spaghetti lots anymore, we're gonna keep it down near the road. Try to have, Norwich is very, I kind of like Norwich's in some ways. Because they have this building up, they have a building envelope provision, which is a nice idea, I think. Which is not only are you gonna make a lot, this is where you're gonna build on. It's not exactly what this is your foundation, this is a hotel building envelope. I think that that's really good because. Where those things happen is important. Oh, I should mention this, on this is actually a Braintree case, because, gosh, it was actually a long time, 20 years ago. On the case. Often, some people want a subdivision and that's all they want. Subdivisions in the state of Vermont are required to either have a design septic systems out there or a notice to the land record that says you may never be able to do this. In the deed. One of those. My advice is if they go the notice to land records, then your bylaw, this state doesn't require this. But my advice is your bylaw says they have to put that notice on the plat in 12.1 or more. Because some people buy lands without doing any title search. But they often get a plat. Oh, I'm gonna buy this section of swamp here, look. It's a nice square of swamp. Oh, it says warning in the corner, you may never be able to do anything in this. Oh. Versus like, I didn't hire a lawyer and do a title search and find in the land record, this notice that says I'm gonna have to do. So my advice is put that on there. But,
Is that common?
what?
A subdivision that doesn't do, sort of review. To
Oh.
ensure that it's a building.
Yeah, reasonably. Yeah, because, they're not gonna do anything. And I had a poor case where a person did that. Bought the, with all the money they could scrape together, right? Built a house. No septic. That was there. Sold the house, next person bought this thing with all the money they could scrape. And the town's like, wait a minute. You don't have, are you doing? The person's like, how can that be? But this was a Braintree case years ago. Somebody came in and said, I want to do subdivision. And a lot of bylaws say they have to tell you what they want to do with the subdivision. And they're like, I don't want to do anything. I don't care. I'm just subdividing the land. So and leave. And I don't want to pay for a septic system. Which they're allowed to do. And they just have to do the most land. My advice is if you get one of those things, and we have the applicant lie. And I call it a no doubt subdivision thing, I don't know why. Is if somebody comes and applies and they don't have any use on the land, it's not like they can build a house, I'm saying. My advice is you give them a subdivision permit. They don't want it, fine. You give them a subdivision permit that says no use is allowed on the spot. You didn't apply for use, we're not giving you. You applied to cut lines and sell lots, have that. And then people can buy those things, and there's a provision that says, should anybody want to do anything on this,
we, the town, may require all of these lots to be re-subdivided and reconfigured in any way we see fit. I know, now, like a lawyer would be like, oh my God, like that's a killer, like, do not buy this lot, right? And the applicant was like, yep, that's what I want. Because it was like cheapest, easiest thing possible. And I raised that because they weren't doing an access road, you know, there was no, how are we gonna get them? I guess we're just gonna walk. And especially if they're commercial uses, it's a little easier if they're just residential uses. But then, you know, when you start to have access roads and is it gonna be a shared access road, all these later decisions that would come up early in the permit process get hairy. And you go, we had the bite of the apple when we issued the sign, we don't get to reopen it unless we wrote something that says we're gonna open it. If you have a commercial, if you guys, Norwich is a different story. Commercial uses, we see this in more developed places where, you might decide to interconnect their roads or with a sidewalk or something. But you don't get to tell them later, you get to tell them the permit time. And you say, you know, you're required to connect, should they ever build next to you? Should this town ever build a sidewalk near you, whatever, you have to connect, any of those future things. But most of you kind of hear some of them. Pieces of forest. Kevin?
Yeah.
The subdivision chapter of the Braintree. Ordinance is a mess.
Oh, okay, yeah,
And
I probably wrote it
well,
a long time ago, though, I was young and foolish.
before you really understood.
Yes.
And so one of the things that we have asked, Kyle, is can you all provide us with some sample subdivision ordinances that we could look at to help us, give us some guidance as to how to sort of clean up our act, if you will.
We oftentimes, can point you to a town we've worked on more recently, and we think this is pretty good. We also do something, that we don't charge. And I call it a desk review, and so you can send us your bylaw or plan or stuff, and say, run this thing through the ringer. Norchester do it. And we did it for Brookfield, we've done some other folks, and just like, give us a markup. And we'll often, so we'll take the thing and we'll often be like, this is weird, or like, no, or sometimes we're a little more helpful and we'll be like, here's a better provision to replace that with. And we just give that back to you. But that's a one and done. The difficulty is then sometimes people think they're playing tennis. Or I don't know who's this like. Then they're like, can you come explain that? Like, you know? And then you're like, okay, I'll come explain, you come explain. They're like, well, can you come back the next time and we're gonna go. And you're like, now we're off to the races. With contract, but that just asking us and going. You got a better provision of this, or you wanna look at the whole darn thing or this chapter? And give us, we can do it.
Well, we specifically asked if you get some samples from other places.
Yeah.
Yes.
Yeah, we are going to, if God is good to me, I've long wanted, and I may get an intern this summer to write. Basically a Lego Bible. That has all my favorite pieces. And then it would say why you need these things next to them. Because, you know, why do you need a severance clause? Well, there's a reason. It says if any of this is part of this bylaw is found to be unconstitutional, the rest keeps going. Why do you have certain definitions? Why do you not say consider? And then maybe have some menu choices. You go, well, you could do this or this, you know, depending upon how tight or loose you want to be on certain stuff. And then you just kind of click it and make your own invention. That's what I would love, because otherwise it really depends if Kyle has, or me or whoever has worked on a bylaw recently and gone, oh yeah, I like the way Bethel handles use and the way so-and-so does such and such. And we only know that, you know, offhand probably for 4 or 5 towns off the top of my head that we did for recently. We can tell you usually,
Stratford,
yeah, Stratford, we've been
Plymouth,
in the guts of Stratford pretty recently.
fairly,
Fairly, good stuff on like forest land and fairly on subdivisions. Actually, we have a good, I think, a good transfer development right provision in fairly for subdivisions. That doesn't use the full-blown weird Flannery's version of transfer development rights. It's just a swap. Just a waiver provision. It's 1 paragraph long. But yeah, so that's, you know, we're always available to do that with a bylaw. That's not a contract, you know, you want us to rewrite a whole bylaw. Do a contract, we do that. We usually, work with you to apply for a grant and get the money to do it. I should mention, while I have you as a captive audience. Did you just do the regional planning? Did you just meet with Kyle? Kyle, young Kyle, you know, we have 2 Kyles.
Yeah, so Kyle, but actually both Kyles.
Both Kyles.
Yeah,
Both.
we had Kyle, Kyle and P&T.
Okay,
We're trying to figure out names for like, old Kyle, young Kyle, now,
original Kyle, new Kyle. Anyways, if you solve that issue, let me know. But there, we're doing a regional future land use map. You guys do a local future land use map. Those maps are kind of important for the bylaws that come later. Your map is, I happen to know off the top of my head, is pretty good. Some towns just have 1 area, and that's gonna be problematic. So for those towns, we're gonna do that. You gotta less, more. Type thing. But when you write your plan, remember that it drives the bylaw. And so if you write plan language that's very, very directed, then that's the only option you can bylaw to. Whereas if you write, that's when you write consider up here in the plan. We should consider large lots. We should consider regulating. Then you can do it over here in the zone. Be mindful of your bylaws just because of the Act 250 exemptions that are in place right now and that are coming. They will apply more in your villages, which you have some small villages. So Act 250 planning, I know they're not formal villages, you can see exactly. Right now, like one of the provisions right now is any commercial structure that is had an Act 250 permit can put 29 or less units in and won't get an Act 250. So it's just your zoning. And so that's a little weird thing. I've yet to see somebody take advantage of that, but I am sure there are commercial things out here and there that have had an Act 250 permit that were just like some weird little industrial use. And somebody can go in and housing. Yeah. Now they're gonna have to do septic and all those type of things too, but a lot of local zoning. Like, you know, we never thought that could be anything. Act 250, I should mention Act 250 too, because I see this sometimes. Usually with developers who are a little squirrely. But they'll come to you and they're like, oh, Act 250 stuff. Well, you know, Act 250 or whatever. Or I got my Act 250 permit, don't worry. That's nice, not your permit. Your permit is your permit, Act 250 is their permit. You can decide different. Your permit does not have to look like their permit. Applicant's job to make them look like their job. You say, nope. For whatever reason, we have to make the driveway here, Act 250 says the driveway's over here. They have an unsolvable problem that they have to go fix. You don't have to do it. Oh, Act 250. And I do see that sometimes people try to roll it. Usually they've gone and done that. Or they're like, don't worry about it. Don't worry about it. We're gonna go do an Act 250. That's not a problem.
When you discuss non-conforming lots
Oh, nonconformities,
and,
yes,
and grandfathering,
and grandfather, yes. Non-conforming, so, we have non-conformities. We have non-conforming lots. And uses and structures, and they all together are non-conformities. And that is a thing that could not get a permit right now under your bylaw. But was legal when it got a permit or when it was built. If it was illegal when they did it, it's not a non-conformity, it's a violation. Yes,
Unless it's been more than 15 years.
unless it's been more than 15 years, right, because the statute of limitations was kind of random. If it's been more than 15 years, and you haven't issued them a notice of violation. Notice of violation, I should mention. You have the powers to issue notices of violation, you don't check with anybody. We certainly don't have to check with anybody and go, I'm gonna issue them a notice of violation, select board or whoever. Select board. Not your call. Going to court, a different call, because select board has to pay the lawyer. Then they say, yeah, we're gonna take this on. Towns don't fine. I had a question just last week. What about fining? You don't fine, the courts fine. But on nonconformities in grandfathering, 4412 covers nonconformities, 24 VSA 4412. Vermont allows you to actually extinguish nonconformities, which is interesting. I don't know anybody who does, but you could do that. The only place I really see it is really in flood regs. We tend to write a provision. Your house is out, way too close to the stream or whatever, and it burns flat. And you want to rebuild it. Well, it was non-conforming. And then you go, well, yeah, but you can't build it back there. You have to build more in conformity than you were. Typically, what we see as non-conformity is of the provisions and bylaws is that they can't increase the degree of non-conformity. And so this is the lot, they're supposed to be 30 feet off the lot line, they're only 20. And they want to build more, and you go, well, you can't build this way, but you can build this way, you just can't get close, you can't increase the degree of non-conformity. You'll often see that. Norwich has a volumetric complex math thing where they actually look at the volume of the non-conformity, which is crazy. Yes, we would say, don't do that. Make the math simple. Often, and again, maybe they're not conforming this way, but they're just going up. Or something. Don't, variances and nonconformities kind of come together. The law is not clear, like, if you're gonna issue a permit for a nonconformity, what is it? Is it a permit for a nonconformity? My advice is it's a variance. It's not a special exemption. It could be a waiver if it's for a dimensional requirement only. But it's something that doesn't comply with the rules, and the only time you get to do something that doesn't comply with the rules is through a variance process. And there's a strict test on variances. But did you have a specific, without naming names, maybe a specific thing in mind on?
well.
Was it use or like a structure?
When it's non-conforming, whether it's used for, how long does that last, especially under grandfathering? If you sit, say, on a lot for a while.
Yeah,
It still applies from when you bought the lot.
Yeah, we usually, now when we're writing bylaws, we will usually write an abandonment and discontinuance clause. And that has to do with structures and uses. I'm always using pizza parlor. Somebody's got a pizza parlor up on Bent Hill, right? And you go, that's not allowed, but it's been there forever. They're non-conformity, they get to keep going. They sell in Florida, stops being a pizza parlor. At some point, my suggestion is you go 2 years something. It no longer enjoys the grandfather. It stops being a pizza parlor.
Certainly, if they turn it into a house, they make it a conforming use. They can't go then back and make it a non-conformity just because it was there. You could allow that, nothing says you can't be looser. But you could be like, nope, if you ever make a non-conformity conforming, you can go back. Abandonment is more to me structure, the house. We have a great one in the town of Sharon on Fail Farm. Cause it's got a tree through the middle. It's clearly doesn't, it's unlivable. It's got a little boat there too, for some reason, I don't know why, in the house. But the house is, small, and clearly has not much of a roof left, not many windows. But should that be non-conforming and somebody wants to come back in and fix it up? You go, no, that's not a house. That enjoys no grandfathering because it was abandoned. And what do we mean by abandoned? We have a thing we write down about that. Same thing, buildings burned down. They kind of half burned down and nobody touches it for a while. At some point you go. For us, it's like you're starting clean. That thing is not a structure. So those are. Right, you'd have to apply for building permit from the get-go, and they're like, well, what's there? And you're like, yeah, that's not a house, that's just dirt. And usually what we say is there's a certain amount of time. Usually we say, that applicants can, they all own it jointly, grandpa died and they gave it to the kids and they all argue all the time, and they're trying to figure it out. And time's going on, like, well, you're trying to figure it out, we can extend it, but. And so we usually say, have had a good process by which the town notifies you, we are considering you abandoned. Answer the mail, if you don't want us to be like, and now the clock starts. Because some of those things are, especially for uses, I think. Where the commercial use is stopped and then they're trying to restart it. It's good to have like, we wrote the letter on this day, you got 1 year to restart it. Cause I've seen ones where people like, oh yeah, they used it as a pizza parlor last week, did they? I didn't, oh, well, maybe, and nobody knows anything, what's establishing record on this. I don't know why I'm always using pizza parlors at night, but now I say it. That's with non-conformities. Variance is very, very, very difficult to get. Waivers are great for things that you're always coming up against. We see it much more in villages where nobody is compliant with the front lot line. Move the front lot line requirements, like if everybody's 10 feet away and you got a 25-foot setback, make it a 10-foot setback. Is the best thing there, but if not, at least waive and allow them to be in there. We have life safety waiver things where we allow it, like, you gotta put on a stairwell or something. If we have affordable housing waivers, we suggest, but waivers are only dimensional requirements. You can't waive a use. Special exemptions, nobody still has that in their bylaw, I don't think. But there's no such thing as a special exemption. But don't do it. And variances, 5-part test, if they meet it, you have to give the variance. A lot of bylaws we see say may, nope. If they meet it, it's hard to meet. But you have to, conditional use standards. Mandatory statutory 5-part test. Common, and this may be in the bylaw, I don't know. One of the second or third one is that it won't unduly adversely affect the character of the area. Common. As prescribed by the purposes of the district. Is what the law says. A lot of bylaws say, well, unduly adversely affect the character of the area. Period. And you know that's not it. So then the neighbors come in and they go, well, it's a lawn. They're gonna put a house on it. How can that not unduly affect this lawn? And you go, but the purpose of the district is to put houses. So that's why it's not. So remember that part. I see that That's just a common, I don't know why people did that, they just forgot the little other part of the law. We see that around there, so there's a few parts of the conditional use you have to meet. You can add on things, the site plan and conditional use both are widely enabled, say, any other standard you wanna write, provided it's understandable. Do not use one of the few things we actually have a court case around is wildlife habitat. Not a thing. As I tell people, my chimney's a wildlife habitat, if I don't use one, I'll have squirrels gonna live in there. And critical wildlife habitat is a term of art, necessary wildlife habitat, term of art, findable by wildlife biologists, wildlife habitat. There's some other things like that where we say. We'll see bylaws like in harmony with nature or something. Right, it gives you the scrunchy face, it should, because like, what's this mean?
Our bylaws talk about a moral character.
Moral character, oh, yes, well, that's good. Yeah, which actually, if you go back to Euclid. There is stuff in there about moral character.
Yeah, but we don't have to do that.
No, we don't have to do that.
But you don't really see it.
Right, yeah. If, that brings me to popularity contests. Or some towns like there, I go through the whole thing, spend months and write bylaw standards, and they're like, yeah, and we'll do all this stuff you said, Kevin, about the student stuff, but really, we'll don't see it. I'm like, no. If you have a hearing. And 80 people show up to say they really like Mrs. Jones and she wants to do this. That's nice. But it turns out we don't have a standard about Mrs. Jones, in the Bible. So my advice to the chair is like. After having a bunch of people on, Mrs. Jones is great, Mrs. Jones taught me second grade. Who here is in support of Mrs. Jones? Raise your hand. Thank you. Now we're not gonna take any more testimony on Mrs. Jones, and whether you like her or not, because we have to look at the bottom. So the rest of the evening is gonna be, everybody gets 2 minutes to talk about a standard that this thing complies with, but we're not doing the popularity kind, because that's not what you're there for. And I have been in some meetings where there's like a rock. They're daring to either kill something if they don't like it, or they like it. And they think it's like they think it's like an election. And the way I shorten that up is I say, the democracy happens when you write the rules, not when you administer. So if y'all wanna have Mrs. Jones, do we like Mrs. Jones? We can put that in the bylaw, but we're gonna go have a hearing and write all that stuff down. So y'all can play. And so, again, takeaway, no personal comments, ever, inside the building, outside the building. Not writing them down, just don't do it, you will be in trouble. And you should be in trouble if you do, because you're an official of the state. You have the full power of the state behind you, you're acting. The state has given you that power, and so with that authority comes responsibility to use it correctly. And you have to know your stuff. Be fair. When you can't figure it out, give us a call. When we can't figure it out, we'll be like, huh, better fix that. If you make a mistake, just undo the process, fix the mistake, and start forward. Try to be clean, because it's easy for a court to go. A court might decide like you interpreted a standard weird, but they can easily decide you were 14 days in your hearing, not 15. That's go back to standard. I should, okay, people out there. That happens to me way too much. Okay, but you know how to find us? There's a phone number, email is the best way to find me. We're full of doing things all the time, so we try to be responsible. We may not be, like if you call me right now and say, Kevin, I want you to be like in July. Okay. Really, And. Anything else? Any other questions? Well, there will be more questions. Like it does that to you. And so then you just give us a shout. And we're glad to, do one-on-one things, glad to talk about what's the permit and process, glad to suggest a fix to a bylaw. And we're learning stuff all that, and the statute is changing, the statute has changed around interested parties a little bit. It has changed around some other things, a piece of law that I wrote that may pass this year, it will be helpful. And that says, if your bylaw is overridden by state law, then the select board can just adopt it without going through all the dang hearing process, because there's no need to. Because essentially, if they change the interested party, that rule applies instantly whenever they say the law is effective, regardless of whether you've updated your bylaw or not. And so why does the planning commission have to? We're gonna adopt this.
What's the over number on that?
Well, it's in the bill, with a bunch of other things. We've suggested some appeal provisions in there, which to me, they've done a couple things, they're not really what I wanted in the appeal. Because we do a lot of work on housing, you want housing. And you can have the best bylaw and somebody can appeal something and hang it forever. And so we suggest not that they lose appeal rights, but that they pay. So if you want to be a pain, you better have a good case, or you're gonna be paying the applicant all the costs. For the affordable housing. So we'll see if that flies. There are a couple other things out there. You see, New Hampshire, is considering just overriding local zoning on some things. We have some ideas around trying to make it easier to do the housing that we want. Not just any old housing, and try to make that more easy in all our towns, because you all need it. Like thousands. Our regional goal for housing, 3,640 units in the next 5 years. That's the one.
That's the one that affordable, that's the hard.
Well, and yes, yeah, even if you had nobody, because I have 7 towns, and no local permits, and it's not like they're way cheap to live. Well, thank you so much for coming. It's so much nicer to come to these and not have like 2 people. Then it's very like an intimate dinner conversation. We get candles, and do this type of stuff.
Well, thank you.
Good, I'm gonna end the Zoom. And we have this, like these PowerPoint slides around there on the web for us. So how can we do this? Here. Sure.
Thank you, Steve.
Close.